Welcome to Justice Unfiltered, a podcast series brought to you by Legal Services Clinic, Ramaya College of Law, Bengaluru, which brings you insightful stories and discussions on human rights, justice, and equality. And our today's discussion is on Queerly Speaking, which focuses on LGBTQIA rights in India and development and history in the legal aspects and society. Join us as we hear from our beloved guest what are the challenges faced by the LGBTQIA community and what are the possible solutions we can get in the social and legal aspects. Now, it's time to introduce our guest, Manavi Atri. She is a human rights lawyer and a researcher working at Alternative Law Forum Bengaluru. Her work also focuses on rights of queer community. She monitors the patterns of news coverage, their relationship with people and politics in Kannada media through her work with Campaign Against Hate Speech. She also appears in front of the self-regulatory body when there is an unethical reportage by the media. We are really grateful to have you on board, ma'am. Our today's topic is on the LGBTQIA plus community. So, for our today's episode of Justice Unfiltered, in the community of LGBTQIA plus, the biggest change that happened in 2018 was decriminalization of Section 377. So, what do you think, ma'am? How has that change influenced or changed the perception of the society after that?
So the decriminalization itself was not something that happened overnight. The 2018 judgment came in the context of a 2-decade struggle, and this struggle began from the streets across India. So it is not something that was happening only in metropolitan cities and urban centers. It was happening in smaller towns, in places like Tumkur, Hosur, basically even from, if you look at the Bangalore as a center, it was happening all across. And this demand for decriminalization of homosexuality and the reading down of Section 377 was a unanimous demand across the community that was there. Because you saw that despite the usage of Section 377 being limited, it was what was used to understand queerness as an unnatural phenomenon, as a phenomenon that is not normal in the societal setup. So the 2018 judgment by the Supreme Court, which basically read down Section 377, made sure that constitutionally there is no more room for homophobic statements, for homophobia to exist in the society. Now, how far that has been able to change the hearts and minds of people, that is something when we all have these conversations within our own families, within our own friend circles, saying that, maybe I am queer or maybe my friends are queer, and that they're seeing somebody who's in a same-sex relationship. The kind of response you see to that is reflective of the fact that that change and that shift has not happened in the hearts and minds of people, but the law has made sure that there is no legal sanction anymore left with that sentiment. So there has to be a shift that has to happen in the hearts and minds of people, which is reflective of this constitution's reality of this day and moment. And so there is no justification left anymore to talk about the criminalization of queer lives.
Since you said, ma'am, there's not been much change even after the decriminalization, why hasn't the judiciary legalized the same-sex marriages after decriminalizing Section 377 or homosexuality, ma'am? Why is it still pending?
So in 2023, 17th October last year, the Supreme Court delivered its judgment saying that in a 5-judge bench that the Special Marriages Act cannot be seen as unconstitutional and cannot be read to include the right of marriage of same-sex persons. So there are two ways to look at this. One is that I think it would be wrong to say that change has not happened societally. Of course, there is change, and one of of the biggest markers of that change today is that when these hearings were happening in the Supreme Court, they were all live streamed, and they were all something that was there being covered by the news in all of in our houses, right? So in that sense, the kind of language in the way that the media was forced to cover it, where you were looking at, say for example, that queer persons have fundamental rights, the LGBTQI community has fundamental rights. So the shift from seeing them as the queer community as some kind of abnormal creatures to saying that the basic bare minimum normal is that they have fundamental rights, that shift has definitely happened. With the live streaming that happened, with the kind of media coverage that happened, with the stories that came out from all of the petitioners, from all of the community members at that point in time, it was clear that there was a demand for the right to recognize marriage. Now one has to understand why marriage, right? Many people say that the institution is a patriarchal institution, that there is the labor of the institution is still left on the women. It is very difficult to break out of that institution. But what we don't understand is it's a simple question of the right to equality, right? Why is it that if a person who is in love in a heterosexual relationship has the right to marriage, the same right must extend to people in a homosexual relationship, right? Now that is the fundamental basis of the argument, saying what rights a person has as a citizen to be in intimate association when they are in a heterosexual relationship, the similar rights they must have in a homosexual relationship itself. That is the foundational basis. So regardless of the fact that yes, marriage is a patriarchal institution, can be construed as that, many people today are not opting into marriage in that sense, but it is not something that one can homogeneously decide and say that the state should not give this right. It is not up to people to say that you may not want to get married, I may not want to get married. That's a personal choice. The question is, do I have the space to exercise that choice? How is that state looking at that choice of mine? So this is in the context of why marriage equality or the claim for marriage equality even came from. Where did it come from? Now it seems like, okay, marriage is just one big celebration in India in that context, right? Across north, south, east, west, wherever. But there is a lot more to it. And what is that more? There is a series of unenumerated rights that flow from the institution of marriage. Now, what are these unenumerated rights? Your rights of making sure you're able to open a joint bank account. You're able to nominate a person for insurance. When you're severely ill or terminally ill, your queer partner is able to make decisions on your behalf. You can jointly own property. You can raise children together. When you pass away, your property, your land, whatever has been acquired by you can be given to your queer partners and not necessarily your natal family. Similar, so it's not just a question of recognition in society, but it is also the question of the rights that come out of this kind of recognition. It is making sure that there is a degree of respect with which your queer relationship is seen in society, and the fact that there are certain rights that, say for example, now if you have to get ration today, and if you have to get it from the public distribution system, your household should be recognized as a queer household even if you're living in a queer partnership, right? So one sometimes thinks that this demand will not have far-reaching consequences, but it does when it comes to all of these unenumerated rights that people in heterosexual relationships and in marriages enjoy, but have not really understood the value of these rights, especially from people who are queer from marginalized and working class backgrounds. So it is in this context that the demand was made. Why was it not granted? It's a complex answer. When you look at the judgment, there's a majority judgment, there's a minority judgment. The Chief Justice, ideally you would imagine when a bench is set up by the Chief Justice, he would be able to make sure that he's able to rally around on some common minimum agreements within the judgment, right? And so you see that all 5 judges have unanimously agreed that there is no fundamental right to marriage, and secondly that the Special Marriage Act cannot be read as unconstitutional. And what has this led to? It has specifically looked at the fact that adoption rights, how do we look at adoption rights? So you have a split opinion there where some judges are saying that for a child to be adopted, you have to be in a maritally stable relationship, quote unquote, as per the CARA guidelines. And they're seeing queer relationships as not necessarily being stable, maritally socially stable. So whereas on the contrary, you have the opinion saying that you have to look at the best interest of the child. Now the outcome of this decision has been that whether it is on the question of adoption, whether it's on the question of these unenumerated rights, whether it's in the question of who is demanding these rights, the final conclusion of the court has been that this is not something that they can judicially do, and this is something that legislatively must be done. So the Special Marriage Act was made with a specific intent, and there is no way for them to read that specific intent to include queer people and to make it gender neutral. And so the ball has been given back to the court in terms of the legislature, and a high-powered committee has been set up. And we already know the high-powered committee has been set up rather opaquely, but it's the committee which has the mandate essentially to now to look at these rights and whether how can we imagine these rights in intimate partner relationships. So what is also a possibility now is that if one were to imagine that marriage equality was granted under the Special Marriage Act, maybe it would have been the beginning of the rights of queer persons in marriages, or it would have been stuck to the book in a particular imagination of marriage. Now, there is a possibility also that right to civil union can be recognized. There's a possibility that deeds of familial association of queer partnerships can be recognized. Now, all of these possibilities exist, and it is up to the community and the movement to see what is it that they want and how do they take the demand forward.
So, ma'am, as you said, as a society, there has not been much of a change. So, ma'am, we've heard of a concept called corrective rape, but we don't know what it is exactly. So, what is it and how is it prevalent in India right now?
So, corrective rape is actually a hate crime. If you look at it in the UN context, in the international laws context, corrective rape is essentially, for those people who don't know, it's essentially what is also very commonly called conversion therapy, which is that when people can't accept your sexuality, they will undertake forcefully, including sometimes medical procedures, sometimes different forms of sexual violence, to be able to make you fit the box of being straight and not being queer. The prevalence of this as such in India is more anecdotal. It's not been studied, but we do have some few landmark cases where the courts have been posed the question of what is it that conversion therapy is doing today, and constitutionally how must we look at it, and how is it harming the rights of the people from the LGBTQIA community. So essentially, conversion therapy happens when your natal family, a family that you're born into, is not able to come to terms with your queerness and your homosexuality. And so then they opt into different kinds of procedures where there is some kind of Ayurvedic procedures, some medical procedures, some kind of sexual violence that is being forced on them to be able to sort of course correct, as the word suggests. So the judgments that I was mentioning earlier, these judgments are essentially looking at what exactly conversion therapy does to the individual, right? So you have a Madras High Court judgment where Justice Anand Venkatesh passed a series of very progressive directions saying that this kind of conversion therapy must be banned, and the Indian Medical Association and the doctors under that, as per the ethics, any such practice must be looked at as professional misconduct. So based on his directions in the Madras High Court in the case of Sushma versus Commissioner of Police there, this kind of the Indian Medical Association had to go ahead and issue this circular to all state medical councils saying that conversion therapy or forceful conversion therapy, coercing people to change their sexuality and to confine themselves within the heterosexual normative, must not exist. So in effect, but there is still a long distance to go, because there are still doctors today, mental health practitioners today, who in the name of making you normal still practice this conversion therapy.
Okay, ma'am. So, I'm a student, and there are a lot of students who might come from the queer community or the LGBTQI community, ma'am. So, what do you think, ma'am? How has the educational institutions played the role, or how inclusive have the institutions been in accepting the community or treating them with fair practices and all?
So I think it starts with before decriminalization happened, when the Supreme Court read down Section 377. In 2014, there was another judicial decision called Nalsa versus Union of India. This decision specifically looked at recognizing transgender persons as an umbrella term and identifying them as the third gender. And by way of this recognition, one of the key directions that they gave for the state and the union government was to identify this transgender community as being socially and educationally backward, which is to say that based on the social and educational backwardness, they must be given reservation, whether in terms of education, whether in terms of public employment. And this was to ensure specifically and address the question that you are asking, that in educational institutions, you do have representation, you do have opportunities given to students from these marginalized communities. Often it's also not understood that the transgender community is also what is more visible, but in some sections of the middle class, the upper middle class, there is a degree of being stuck around the question of sexuality and not really addressing the question of gender and the non-binary gender in that sense. So the transgender persons, as per the Act, also the Transgender Persons Act and the judgment also is a wider term. So it includes many socio-cultural identities of Jogati, Aravani, Shiva Shaktis. So these are rooted in Indian culture, and they have been part of different kinds of practices in even a village setup, even rural setups that exist. And what has been happening over the years is that from a time when they were participating in these and socio-cultural activities as a way of participating in society, now they have, similar to a kind of caste system, they have been restricted to being only those socio-cultural identities. And so to access education, there are many things that are needed to be done. One is that the horizontal reservation must be applied. So vertical reservation is essentially on basis of your caste. Horizontal reservation is also on basis of, say for example, in the Karnataka context, 1% reservation is given when it comes to transgender persons. Now, what do you do with these reservations? You're supposed to, after 12th standard, be able to go to an educational institution, and these number of seats must be reserved for you. But is there enough? Till 12th standard, I haven't had an education. I can't even read and write Kannada. English is a much different context altogether. So is the question of just mere reservation is also not enough. For substantive equality, there has to be concessions and relaxations given on the thresholds of being able to enter these educational institutions, firstly. So it's not, when you look at the question of education, it is not just one must not understand it from the context of it being private universities alone. One has to look at the responsibility of the state and see what role have they played in ensuring this reservation and ensuring the first barrier is entry. After that, what happens within the college campuses? How do you make these spaces more inclusive? How do you understand the concept of gender? How do you understand the concept of what kind of humor you crack, right? In college, there is a lot of relationship and association built over the kind of humor that students enjoy. And so how is this humor sometimes targeting some communities? So all of those, in my understanding, comes after and is something that's already in the works. But the very first responsibility of the state to ensure that they're able to enter these educational institutions has not been fulfilled as per the Nalsa decision.
Okay, ma'am. So, if anyone faces any discrimination in those institutions, what is the recourse they can take, ma'am?
So each institution, regardless of educational institution, workplace, any place that you are in a public space that you engage in, the Transgender Persons Right to Protection Act is there, right? And this specific legislation, though it has many problems because of the way it was not consultative, it came right after COVID, it did not not understand the nuances of the gender identities, and so there are many challenges with it. Regardless, there is something very fundamental it does to the question of discrimination, where it has specific provisions saying prohibition of discrimination, right? And these include places of education, it includes places of employment, and all of these provisions are included in it. Similarly, in Karnataka, there is also a policy on transgender persons, and as per that policy, each institution should have a separate grievance redressal committee. Now, that this is a question that you all must ask yourself, that in your own college, does that committee exist? And if it doesn't exist, why is it that? Why is it that, and what do you as students need to do to advocate for that committee to be set up, right? In some cases, in some institutions also, that if these are such kind of discrimination and harassment is sexual in nature or is casteist in nature. If it's sexual in nature, sometimes it's covered under the prevention of sexual harassment, the committees that are set up, the ICCs that are set up. In case it's casteist, it's also covered by the grievance redressal cell of the SC/ST committees. So each of your colleges are also supposed to have these cells, the SC/ST cells, to be able to prevent any kind of casteist abuse that is happening. So the implementation of this is something that really you should be asking within yourself, saying, does your college have it? Do your other schools friends who are in other colleges, do they have it? And what is it that is stopping the students also for demanding that these committees and these kind of recourses exist?
Ma'am, speaking of the laws, how has the Transgenders Persons Act 2019 been dealing with the discriminations against transgenders? And I had a doubt that, does the Transgenders Persons Act limit only to transgenders, or it covers the other communities of LGBTQIA community also?
So, like I mentioned, the 2019 Act, one has to understand in what context it came. Any act is only as useful as much as the people decide to use it as a normative framework of protection for themselves, right? The act came rushed right before COVID. The rules came during COVID, when people did not have basic amenities of food, medicine. Many of them could not get ART, which is a critical therapy which you have to have when you have AIDS and HIV. And so the kind of struggle that the community was facing was a struggle for survival. And at that point of time, the union government decided it was a good time, within this limit of consultation days, to be able to produce a rules draft, and then went ahead to not translate it into any languages. That it is to say that as if everybody in India speaks English, and they didn't even translate it to Hindi to that extent. So there has been many critiques of the Transgender Persons Act and the rules itself. It also starts from the articulation saying transgender persons are third gender as per NALSA, right? They've been recognized as the third gender, which is to imply that the male gender is the first gender, the female gender is the second gender, and the transgender is the third gender, right? So there have been many critiques over the period of time with regard to how the state has understood the transgender person's identity, and consequently the act and the rules. Now, does the act provide a normative framework to address the question of discrimination? Yes, it does. It does have provisions which are progressive, which look at the prohibition of discrimination, like I mentioned, in education, in employment. It also have positive obligations from the state and duties to ensure that the way the society looks at the question of trans persons and queer persons is addressed differently, that they must do awareness programs, they must provide different kind of training. So it does have a larger than life framework within itself. As for the question of who are these transgender persons and how do you understand them? So the definition in section 2K specifically looks at transgender persons, which means that those who don't identify with the gender that they were assigned with at birth. Okay. Then it looks at the word of genderqueer, gender non-binary. It also looks at Hijra, Aravani, Koti, Shivashakti, Jogappas, and many other socio-cultural identities within it. So the transgender as a term itself, we have to understand it is not just people who dress differently than with the gender that they were assigned at birth, but it is a series of these identities which we must look at inclusively and wholly when we understand the context of transgender persons.
As we spoke about the decriminalization and same-sex marriage, equality of the community and all. So, what can we as law students, or what can we as a society do to for making sure that the equality is given to all the communities in the LGBTQIA plus community? So,
I think there's 3 simple steps of what we can do. One is we have to understand what these judgments have done, right? Very clearly, the Navtej Singh Johar judgment very specifically stated that we are, as the constitution, stereotypes can't be perpetuated because stereotypes are not in line with the constitution, right? So this is something that we have to think about in all of our conversations, in our friend circles, in our community, in the law school itself, that what are some of the stereotypes we are perpetuating and how is it that we can counter them and reflect on them. So each of these judgments, they're not just necessarily about the law. They are about how we can look at practicing the constitutional morality, how we can look at practicing certain aspects of the constitution. One being that we don't further stereotypes. Two being that we understand the foundations of equality and we address people with that kind of respect, non-judgment and understanding and so on, right? So that is insofar as reading all these judgments to understand. Yes. But the second part is how do we read these judgments, right? So something as Alternative Law Forum, the place that I work with, we've been very invested in is that each time in the last 20 years that a judgment has come out, we feel as lawyers it is our responsibility to simplify those judgments and make them accessible to the community to understand them. So because it's not that the community can't understand, it is that the language of the law is so inaccessible, so hierarchical that people whose the law is for, they can't understand it because of the way it's written. As law students, you know the judgments run into hundreds and thousands of pages, and really what can be said in a sentence is said in 5, right? Yeah. So some of the work that we have done, as you can see, is we've published many booklets like this. This is the Right to Love booklet, which essentially looks at the Navtej Singh Johar judgment and simplifies it to say, in each thematic, what do the judges say and how do we take it forward. Similarly, just day before yesterday, since we've completed 1 year of the marriage equality judgment, we have released a booklet called A Dream Deferred, a denial of marriage equality, which is to say that we hope this dream of marriage equality has been momentarily deferred, but in this moment, what is it that's something that we can do? We have also published some pamphlets which help sort of simplify the judgment in a very simple way of what is the context, what happened in the court, each question of law, what are the directions, what is the conclusion, and really what's the way forward, right? So this is something that we are committed to, and we really hope people who are law students read this material to be able to engage and understand the queer community at large. And finally is to, as law students, engage with, say, for example, the high-powered committee, right? Now, the Supreme Court has set up a high-powered committee. As you've already asked me also, that in your colleges and institutions, there are people from the queer community that are there, right? Yes. Now, what are their experiences? What are some things that the high-powered committee must understand in understanding the rights of queer people? So some foundations have already been laid down. You can't file false FIR. Police must not harass queer people. They should not be forced to go back to their natal families. All that context and work and has been judicially done. But now, how do we make these colleges spaces where people can be themselves, and what is it that we can do to implement these judgments in our own context and take the recommendations forward to the high-powered committee? So essentially, these are the 3 things that I think should be the way forward, some of the ways forward in which students, especially law students, can engage with the queer community and with the questions of marriage equality.
It's a really great initiative, ma'am, to simplify all the judgments and let the public know and let them read it by themselves. Yes. Which the simplified version does.
Yeah.
And if you give me an opportunity, I'll like to borrow this and
yes,
read it.
Yes, of course. Thank you so much. Thank you.